Appeals Court. I am William Meade. With me today on the panel are Justices Blake and Brennan. If you haven't been here before, we have read everything. It's my best advice to get right to the point. Each side gets 15 minutes. You needn't use all of your time. There is no rebuttal. With that, I'll call our case 22P283, Any Bridge Contractors Incorporated versus the City of Lawrence. Mr. Almeida.
Thank you, Your Honor, and Your Honors, may it please the Court, Brian Almeida for the appellant and cross-appellee, New England Bridge Contractors, Inc. We are here before the Court today to respectfully request that this Court reverse the summary judgment decision of the Bristol County Superior Court and also affirm the subsequent trial judgment of that same court, save for one grievance that the appellant has with that particular decision. Starting with the summary judgment decision, the appellant New England Bridge's largest bone of contention with respect to that decision is that it essentially made a blanket legal judgment with respect to a very fact-intensive issue as to the apparent authority of various agents of the City of Lawrence to authorize additional work.
So what do you say the disputed facts are, right? Because the contract says what the contract says. There's not a factual question about what the contract says. Isn't it really about whether or not there was an oral agreement to alter the contract?
I think that's one way to characterize it, Your Honor. I think.
And is that even if there was an oral contract, is that enforceable as a matter of law?
Well, I suppose, at least the way that I've thought about it is less an oral contract per se, but whether or not there was the ability for the City of Lawrence to authorize additional work that at least New England Bridge's position was contemplated under that agreement. And in this case, let me backtrack by not saying work per se, but additional materials needed to complete the task under the contract. So I suppose that I don't think of it necessarily as rewriting the contract, but operating under that contract and supplying additional materials that were needed to complete the work thereunder.
So as to that piece, if you could say it in one sentence, what would you say the disputed fact is?
Whether or not the agents of the City of Lawrence in fact approved the use of those additional materials, and then I suppose there's a legal issue as to whether or not.
But not in writing, though.
I'm sorry, Your Honor?
It wasn't approved in writing, is that what you?
It was not, Your Honor.
And doesn't the contract itself require any changes to be in writing?
Well, I suggest, Your Honor, that the contract also mentions whether or not there would be additional direct costs of the contractor that would be reimbursable. It expressly says that the quantities of materials used under the contract would be estimates. So I agree with you that the contract does contain a provision that does say that amendments to the agreement need to be in writing, but I'd suggest that what happened here wasn't really an amendment to the agreement at all.
Your position is that travel and other expenses includes $300,000 worth of cement?
No, Your Honor, I agree with you that I think that the enumerated additional provisions of that clause do seem to suggest that it wasn't meant to, as you say, encompass $300,000 of additional materials. I would more focus on the reality that the materials in the contract were deemed to be estimated. And there was a process that the City of Lawrence set up by going through Face, Bothard, and Thorndike, who I'll refer to as FST.
Do I have the timing right? In May, your client submits a written request for a $40,000 change order.
Yes, Your Honor.
Right? And then in July, they say, the scour, what's that, the gouge, is 15 times bigger than we thought. And then they just have a chat at the side of the Merrimack and say, well, let's go down and let's go. Is that, do I have it about right?
I think you do, Your Honor. I think to backtrack slightly, I think that change order certainly does reflect an awareness of the reality that there is a procedure for undertaking a change order. However, I think that this sort of goes into the proposition of the Selco case with respect to whether or not there's an equitable adjustment to the contract or if there's a change in the price that requires a change order. And the distinction that I think that these cases draw, at the very least as far as I could read it, is that if there's a change to the cost per unit of the material to go into, for instance, in the scour, that would require a change order. But that if there's a change in the volume necessarily of the material, that the case law, at the very least with respect to this debate of whether or not there's an equitable adjustment to the contract occurring or not, that's the distinction that the cases seem to draw. And it's our position that we seem to fall on the side that this is not an equitable adjustment to the contract.
What would you say is the most helpful case to you in terms of, I know there's no exact facts as they are presented here, but what's the most analogous fact pattern in a reported case?
So I think maybe not analogous in terms of fact pattern, but sort of overarchingly sort of setting the seminal rule in this instance, I would refer the court to this court's decision in Thomas O'Connor versus City of Medford. That's 16 Mass Appellate Court 10, 1983. That case stands for the proposition that the appropriation statute, which we're sort of obliquely discussing, that's General Law Chapter 44, Section 31. This case, Thomas O'Connor, stands for the proposition that this statute was meant to govern municipal finance and was not meant to foreclose claims of contractors, such as my clients in this instance, from claiming that something happened during the course of the contract that would require there to be equitable relief or contractual relief stemming therefrom. So I think that's the case that would be most helpful on that point, sort of overarchingly setting the tone that the appropriation statute was not meant to function in the way that it's being used in this instance.
Could I ask you about the video? I've watched it a couple of times. What is it, what am I supposed to see?
That's a great question, Your Honor.
Thank you.
I'm not sure that it really made it into the transcript, but at trial, I think that there was also confusion as to what was being seen. If the court was, my memory was that video was introduced to refresh the recollection of the witness rather than as evidence substantively. And I think that the witness's recollection was that it was very difficult to see at the bottom of the Merrimack River and that the scour was difficult to discern. And I think he identified stray logs and, other debris down there. But I don't think that at trial it was really contested that the sheet metal wasn't bent back. So I think that the probative value of the video in that instance was somewhat limited.
On your second issue of prejudgment interest, is there any discretion for the judge, or is it an obligation to use date of breach or date of demand?
Well, I think that's an excellent question, Your Honor, and I think that that's something that's been sort of debated in the briefs as to what the requisite standard of review is. I'd suggest that the standard of review is not abuse of discretion when there's something in the record that makes it just somewhat obvious on its face, something uncontested that suggests that there was a demand made. And
so the demand was August 15, 2008, right?
That's correct, Your Honor.
And Section 6C does use the word shall.
Yes.
But are there cases that suggest that the judge has discretion?
Well, I certainly agree that there are cases discussing prejudgment interest generally that suggest that there is discretion in this area. But I agree with you, Your Honor, that I focused on the word shall in that statute and interpreted it to mean that if there's something in the record, and in this instance I'm referring to what's on Joint Appendix Volume 2, page 59, pages 44 and 45 of that document, in the process of submitting agreed or not agreed findings of fact and rulings of law, there was a concession that a demand was made on that date. And our suggestion is that with that being done, the court did not have the discretion, although it generally would in determining prejudgment interest as a general matter, but under 231-6C would then be obligated to find that that was the demand date and that therefore prejudgment interest should run from that date.
So accepting out the interest, is the dispute right now roughly about $18,000?
It is, Your Honor, although interest is quite considerable given that the case, I think,
sure.
dates back to 2011.
The contract dispute, as you've framed it, is about
Yes.
an $18,000 dispute? Okay.
Yes, Your Honor. It is, and that turns to my brother's appeal in this case, which is of the underlying trial verdict that stemmed from that contractual dispute, that portion of which was not resolved on the summary judgment appeal. The summary judgment decision that we're appealing in this instance. Turning to that, Your Honor, just to address some of my brother's arguments while I have the floor, there's a contention that this claim was waived during the course of the litigation, and I'd suggest that that is a gross misreading of the proceedings that predated the summary judgment proceeding and those proceedings that followed. I turn the court's attention to the Record Appendix, Volume 1, pages 8 and 19. That would be the first reference I made to Volume 1, page 8. Is the complaint, paragraphs 15 and 17 thereof, which make out this claim. I know that it's complicated given that there's, a contract price, a change order, an adjustment to that one way or the other, but those allegations of the complaint do make out this contract claim. It's then referenced again on Record Appendix Volume 1, page 19, which is in opposition to a motion to dismiss that was filed by the City of Lawrence during the infancy of this case. And that's where we get the famed Wacus affidavit, in which there's what I'd suggest a cherry-picked quote that suggests that the only claim in this case was for the larger amount that was determined on summary judgment. I'd suggest that the motion to dismiss itself is instead focusing on the allegation that the claimed amount is for additional labor and services rather than for additional materials. So the affidavit that's being submitted is directly addressing that contention and is in no way waiving any other claims that were brought in the complaint. Turning to my brother's arguments with respect to Massachusetts General Law, Chapter 30, Section 39I. That is a statute that sets out a procedure unique to public works contracts. And this was the subject of a motion for directed verdict at the conclusion of the plaintiff's case at trial. I'd suggest that the court very well could and did find that this statute had been satisfied sufficient to allow the plaintiff's claim to proceed. And in that way, Your Honor, I would, in thinking about this statute, in reading it this morning, I see that there's essentially 3 steps to that statute. First is the approval from a duly authorized engineer or architect in charge of the work who is duly authorized by the awarding authority to approve such decisions. Second, there would be a writing that evidences that approval. And then third, there would be a certificate issued by the municipality in this instance under the pains and penalties of perjury that authorizes that occurred. And in this instance, Your Honors, I'd suggest that at the very least, 2 of those 3 requirements have been met. In this instance, there was approval from both Andrew Wall, the city engineer of the City of Lawrence at the time, and then also approval from Face, Bothern, and Thorndike, FST, the supervising engineer for the project. And that second, the Andrew Wall letter, which is a joint appendix 5, page 588, was written confirmation that there was approval to modify the performance under the contract to excuse not bending the sheet metal back. And that the third requirement, the certificate issued by the City of Lawrence under the pains and penalties of perjury, while not occurring, given that that's the responsibility of the City of Lawrence to issue such a certificate, it would not fall upon my clients to satisfy that requirement unilaterally.
So we, as you know, can affirm for any reason apparent on the record. And I don't know that the city has raised this, but one question that I have is your argument about the enforceability of this oral agreement, doesn't that conflict with the statute of frauds?
Well, at the very least with respect to the trial verdict, Your Honor, or are you referencing the summary judgment decision?
Summary judgment.
Well, again, Your Honor, I certainly acknowledge that there is the potential argument to suggest that there was a new oral agreement over and above the written agreement that was in place. I still think that the way that...
And if that's so, does it satisfy the elements of the statute of frauds?
I'd suggest that it wouldn't, but I still think that, again...
Still enforceable.
Well, the written agreement that exists did contemplate that there would be additional materials, that the materials are estimated. And while I certainly agree with Justice Brennan that given that my client, New England Bridge Contractors, was aware of the procedure for a change order, it certainly should have behooved them to go and get a change order.
Right, but to Justice Brennan's point, I mean, I assume that a company whose name is Northeast Bridge Contractors has worked on bridges before, and 15 times more concrete than was contemplated by the written contract seems odd, a gigantic miscalculation on the part of the bid. What does your client say about that?
Did you say 15 times, Your Honor?
Yes.
Okay. Well, I certainly agree with Your Honor that that is a rather gross miscalculation.
Seems like a lot of concrete.
It certainly is, Your Honor. And my 2 points with regard to that are one factual and one legal. As a matter of fact, Your Honor, I'd suggest again that the key issue here is that New England Bridge then refers this issue immediately to the city engineer and FST and says, we have much more material needed than we anticipated. What do we do? And they said, fill the hole. They didn't say, go get a change order. They didn't say, talk to the comptroller. They said, fill the hole. Secondly, Your Honor, I'd suggest that, again, turning the court's attention to the Selco case, which is the case that the summary judgment decision chiefly relies upon in deeming this to be an equitable adjustment rather than an actionable equitable claim. In that case, again, different because it's not adjusting the quantity of materials, but it's adjusting the price, unit price of the materials. The unit price contemplated by that contract was 1 cent per unit, and the price that ended up being sought in the equitable judgment was $220,000 a unit for a difference of 22,000 times. So I'd suggest that by orders of magnitude, this is not an equitable adjustment as contemplated by the Selco case. I see that my time is up, and unless the court has any other questions.
Seeing none, thank you.
Thank you, Your Honor.
Mr. Posner.
Members of the panel, may it please the court, my name is Bernard Posner. With me is Sam Gates, and we represent the appellee and cross-appellant, the City of Lawrence. So I'm first going to discuss the motion for summary judgment. And the key thing for the summary judgment motion is Chapter 3039N, that equitable adjustment statute, which clearly applies here. And that's that.
Why is it not, as Justice Blake asked, just a simple statute of frauds issue?
Yeah, I am not sure. It was not briefed at the summary judgment stage.
Fair enough, okay.
So, but I do understand that anything in the record, Your Honors can base your ruling on that. So it does seem like it would apply. But equally so, the equitable adjustment statute would apply. The key here is where there's a latent condition, something that can't be readily seen. The statute's designed to kind of take that risk out of the bidding process. So the city is not going to have higher bids coming in because bidders are going to be, increasing their bids because they can't see something and they don't want to be stuck with having to.
But it can't be the first time that the city has entered into a contract where once the contractor gets in, there needs to be additional material. For example, in this case, the amount that they needed seems to be fascinating in terms of the initial bid, but what normally happens, take it out of the context of this case, the city enters a contract, the contractor comes back and says, you know what, we underestimated, we need X more of something. What's supposed to happen?
A change order, the process.
A written change order.
A written change order. And that's the second argument, is that even taking the equitable adjustment statute out of the picture, the contract's clear that whether you characterize this as an extra work, reimbursable expense, it has to be done by a written change order. There is a cap to the contract. It's like $280-something thousand. And without that written change order, it can't go forward. So that's the process.
So you try to get that change order, and there's no meeting of the mind, so it doesn't happen. So you have a contract that's been signed. Neither side can comply because you can't agree about this change. What happens?
Sometimes the contractor will do the work under protest, and then the agreement.
Reservation of rights.
Yeah, because then the project will move forward, and they'll get paid other portions that, other amounts that may be owed. I think that I'd submit to the court that's usually what happens. What I think should happen is there should be a break in the work, and they should work it out and come to an agreement. But once the project is started, there's often external deadlines that need to be hit.
Do you dispute that someone from the city said dig the hole?
Dig the hole, Your Honor, or fill the hole? I just want to make sure.
Dig the hole.
The hole was already there, so we're talking about a scour. There were multiple dive reports that they estimated. So there's somebody from Mass Highway.
Now you have this hole under the water.
Yes.
And they say, we don't have enough concrete.
That is disputed, yes. And that was something that the summary judgment court ruled on.
What about that is disputed? What is the issue of material fact there?
The court looked at whether FST, which was the city engineer, and Mr. Wall, who was the city engineer, employed by the city, approved that work. And if you look at the affidavit that was submitted, it's actually in the supplemental appendix. It's Mr. Perez's affidavit. The exhibits to that affidavit make it clear what happened. There was no one on site when that material was put in. Mr. Khalifa, who was actually FST
No one
engineer.
on site from your side of the
From,
vein.
exactly, yeah, I should
Okay.
be clear. There was no city engineer, and Mr. Khalifa was not there. They get there, the boat's pulling out. The material has already been put in. They say, what's going on? We want some video evidence here of what you saw, because supposedly Mr. Wakis or somebody on his team had gone down and discovered that the hole was bigger. That video evidence was never submitted. Then they request a change order with proper backup. The backup is not provided, but the change order request is put in. The change order request is denied. This is after the work was supposedly done. I mean, it gets to the bent sheet metal and the other trial issue. But that's absolutely disputed, and the summary judgment court ruled on that. They said there's nothing in this summary judgment record that suggests that there was this waiver, whether you're looking at an apparent waiver or apparent authority or actual authority, that they just say that it didn't happen. The summary judgment court says that. So that absolutely was disputed and ruled on by that court. But, you know, talking about whether they had the authority to do it is another question. And in the municipal context, you really do need actual authority. The cases are clear. There's a Castinos case, I may be mispronouncing that. That's dealing with a quasi-agency. It's a housing developer or housing development. And the court says, we're going to treat them as a private entity. They have private entity contracting powers. So that's very different than looking at a municipality, whether they can waive something, whether they have the authority to waive it. And you have to, the court was very careful in looking at this, the summary judgment court. Apparent authority is usually not enough. You really need actual authority. And that wasn't here, and the judge did look at that. I mean, it goes to the appropriation statute as well, because you can't have a municipal employee come in and waive statutory requirements. You know, they can come in and talk about, you know, waiving something of the contract. It does need to be in writing. They can't waive the appropriation statute, and that would apply here. The question that always comes up is whether that true breach exception applies, because, you know, there are instances where the appropriation statute does not prevent recovery. Here, it's very clear that New England Bridge is looking for, their whole theory is trying to recover under the contract. They don't claim that this was an amendment that was necessary. They say, well, extra materials were called for, you know, you can have an estimate under the contract. This was, so it's very far from that true breach scenario.
Can I ask you just to turn for a moment to the trial issues? You claim that the judge was clearly erroneous on two factual issues. One, that you say Mr. Perez said that the better decision was to cut and replace.
Yes.
The judge clearly credits Wakis. He indicates that Perez gave conflicting testimony. Why wasn't he free to do that? And then find the facts that he found.
I mean, he says that, but he doesn't really, the example he provides of conflicting testimony is that testimony about, I agree with Mr. Wakis. And when you look at that testimony, it's not even a question. You can't even make an inference from it. He clearly says in multiple instances, this is a thick sheet metal. It's going to be very difficult for New England Bridge to rebend it. Probably would have been easier for them to cut it, cap it, and put it back. He says that. He does not agree that they can leave it bent.
What if he just, what the judge just, for whatever reason, looking at the witnesses, says, I believe Wakis. There we go. And he said X, so I find X. Why was he erroneous in doing that? Clearly erroneous.
He's not erroneous in doing that necessarily. He's erroneous in relying on a misstatement of testimony, because that's what that was. And that seems to be mentioned. It's mentioned both in the motion to the Rule 59E motion. It's mentioned in that decision. It's mentioned in his findings of fact. That's clearly an incorrect finding of fact. The other piece that I would like to discuss is the video while we're talking about this. The video was put in specifically to show that there was no riprap. And riprap are these big boulders securing the outside edge of that sheet metal. The contract called for two things. You've got to fill in the scour, or a few things. You've got to rebend the metal, which protects the scour. It prevents the scour from reoccurring. And then you need to secure that metal so it doesn't bend more. There was no testimony provided at this trial that FST or Mr. Wall approved leaving that sheet metal unsecured. The way it was left, it could continue to bend with the current of the river. That was another finding of fact, and it was a finding of fact that should have been made that the judge did not make. The reason we put in that video is because it clearly depicts that lack of riprap.
But you agree, I mean, Wake has testified in effect that we thought a different, I mean, I'm paraphrasing, we thought it was better to go a different way. Their engineers, their people on site said, makes sense to us, so that's what we did. And so if that's the case, why, again, is the judge, as the finder of fact, not free to find that?
He is free to find that, but he's not free to find that and then also reference incorrect statements of the testimony and saying, well, in any event, even the city's witness agreed with Mr. Wake's. That's the improper part of that. And again, the other improper part is not finding that the lack of riprap. Because the contract needs, this goes into the rulings of law issue. The construction parts of the contract, I think the law used to be a bit different, but they limit it now to construction, needs to be strictly complied with to recover. And that was one of the city's other arguments, is that, we went into this, the city went into this not realizing that there was any oral agreement. The first time this comes up is at the trial that supposedly the city orally approved this. But even if they approved it, they never approved leaving it unsecured. That is a failure to strictly comply with the contract and would prevent recovery. So that was the other issue.
Okay, but you don't dispute that the city or someone on their behalf said that there were divers that went down and said, this is okay, Department of Highway Safety, or it was Highway Safety, but the Highway Public Works, I should say, went down and they approved the job?
No, that was disputed. Mr. Perez testified that was not approved. The city never did that, and that was, and to your Honor's point, I mean, the judge is free to weigh the credibility of both witnesses and make a decision on that. Again, he's not free to rely on misstatements of testimony.
So when we talk about design and construction, at what point, how do we know at what point it becomes design and construction as opposed to, in other words, as opposed to a deviation that was within the parameters of the contract? If they bent it right instead of left, if they turned it up instead of down, if they cut it and left it versus cut a half an inch shorter.
Yeah,
Isn't that really for the folks on site to try and sort through?
It is a bit of a gray area, although not in this instance where there were only a few things that needed to happen under the contract. Bending that sheet metal back was a key part of the contract, which Mr. Perez testified to. He said, this needs to be bent back and straightened to prevent this from happening again. I mean, this happened over a period of 20 or 30 years. There are dive reports going back that were put into evidence that show that this has been there, and it would develop again if this is not properly secured. So these are key parts of the contract. It goes to 3039I, and why this is not a minor deviation. The key on that is no matter what happened at trial, this needed to be in writing because it was modifying the construction parts of the contract. Under 3039I, that's very clear, and it just didn't happen. The judge made an interesting ruling. He said, well, you can modify the part of the contract that requires it in writing. That we can modify that and say that's de minimis, so then anything relating to the construction can be changed. It's very circular reasoning that essentially guts the statute of any force. And that's what the judge indicated here, that the oral, you could orally change the written requirement, which then allows you to change the construction part of the contract. It took us a while to wrap our head around that, but that's essentially what the judge said.
And I have one last question on that, or sort of related issue, is with respect to the judge's finding that there was no explanation for the partial payment. I think you cite Perez's testimony that they said the city didn't pay because they didn't complete the work.
Correct.
Right. Again, does that, in your view, is that it? Is that the best evidence you have of that, as opposed to, how does that explain a partial payment as opposed to just, well, we're not paying for it, you didn't do the job?
Well, I'd submit that it doesn't necessarily explain that, but again, because they did not strictly comply with the contract, it doesn't need to. It's not the city's burden to prove the value of the work in that instance. To recover on their contract claim, NEB needed to show that they strictly complied with the construction aspects of the contract, and that failure to put the riprap in is a clear indicator that they just did not. Putting aside the bent sheet metal, because there was a dispute on that issue at the trial, and again, the judge was free to weigh the credibility and rule on that.
As far as we know, the bridge is still standing?
It is, it is, yeah. 30 years from now, you know, yeah. Yeah,
Just
no.
one question about the
Sure.
interest. The 6C seems to be obligatory. It says shall. So was it an error to run the prejudgment interest from the date of the complaint as compared to the date of demand?
Yeah, and we would argue, yes, and the date of demand is different than.
Than what your brother?
Than what, yes, because, and I would invite the court to look at that complaint carefully. The amount owed versus the amount in controversy, I'd submit that there's no way to get that 18,000 delta from the numbers that are included in paragraph 16 and 17 of the complaint. Couple that with the affidavits that were submitted in connection with the motion to dismiss and the summary judgment motion saying we are here solely looking for extra materials under the contract. We're not claiming there's anything else owed solely and exclusively as used. So, you know, when did that first come up? It was after the summary judgment, and then we would submit that is the point of the claim. where
Thank
it's
you.
made.
We're going to have to leave it there. We'll take this under
Thank you.
advisement. With that, I'd like to thank our court staff, our clerk's office, our court officer, our excellent timekeeper, and my panel. We'll stand in recess.
Thank you.